Canadians are surprisingly bad at getting their wills done. According to an Angus Reid survey from 2023, only about 23% of Canadians 35 to 44 and 34% of Canadians between 45 and 54 have an updated will in place. Now let's think about that group for a second. These are also the years when many Canadians are raising children, building wealth, buying homes, and in some cases running businesses. In other words, sure, you're less likely to die, but the impact of your death prematurely probably matters more than any other age. Most married parents in Ontario assume that if they die without a will, everything goes to their spouse. This is not always true. In some cases, your children could legally inherit your estate immediately. And if they're minors, their inheritance could end up being controlled by the government until they're 18 years old. So let's walk through what actually happens when someone dies without a will in Ontario, especially if they have children or own a business. First, a quick definition. Dying without a will is called dying intestate, and when that happens, Ontario creates a default estate plan for you using their provincial rules. To be fair, most families think, hey, we're married, we have kids, surely everything goes to our surviving spouse. Honestly, it sounds pretty reasonable, and that's what a lot of people do think. But Ontario's rules don't always work the way people expect. First, some assets, they transfer automatically. For example, a jointly owned house will bypass the estate and go directly to the surviving spouse. Life insurance with the named beneficiary, RSPs, tax-free savings accounts, any registered account with a named beneficiary will bypass the estate and go right to that person. But what about everything else? This is where things get complicated. If the estate is large enough, over $350,000 in Ontario, the children may legally inherit part of that immediately. Not later, not after the surviving spouse dies, right away. If there's one child, the remaining estate will be split 50-50 between the spouse and that child. If there's multiple children, the spouse will receive 1/3, while the remaining children will split the remaining 2/3 of the estate. And now here's where we hit the real issue. Minor children can't legally inherit those amounts directly. So if a child inherits part of the estate, that money may end up being managed by the Office of the Public Guardian and Trustee. The surviving parent does not automatically control those funds. They may need approval to access the money for things like education, medical expenses, childcare, and other costs related to raising a kid. The money is generally invested conservatively until the child turns 18, and then the child receives the money outright. No restrictions, no protection, just a check. Happy birthday, Junior. This is one of the reasons many parents use trusts in their wills, so the assets can be managed more gradually and responsibly for the children. More about this in a previous video, which I'll link below. Now let's talk about business owners, because this can be much more complicated. If there's no executor named in the will, the court will appoint one to manage the estate. Until that appointment happens, there can be delays accessing corporate shares or making decisions. And while your corporation does not die when you die, operations can still freeze if nobody has the legal authority to act. This can create problems with payroll, banking, contract approvals, CRA filings, or day-to-day operations. Now let's talk about taxes. For tax purposes, Canada treats your death as a sale. The government acts as if you sold everything you own immediately before your death at fair market value. This can create major tax bills, even though nobody actually sold anything. A surviving married spouse may be able to roll over shares on a tax-deferred basis, but if the shares pass directly to children, capital gains tax may be triggered immediately, and without a properly drafted will, many advanced post-mortem tax strategies may no longer be available. This can mean more tax, less flexibility, and less money ultimately reaching the family. Now let's make this even more uncomfortable, because common law couples in Ontario are treated differently. Many people assume common law spouses have the same inheritance rights as married couples. They do not. In Ontario, a common law spouse has no automatic right to inherit under intestacy rules. Even if a couple has lived together for many decades, even if they've had children together, legally the children may inherit everything. And if the children are minors, the inheritance would again go to the Office of the Public Guardian and Trustee until they're 18. Meanwhile, the surviving common law partner may need to go to court to make a dependent support claim to access the funds. In practical terms, mom or dad may end up in a legal battle involving their own children's inheritance while trying to hold the family together after death. For many families, dying without a will creates delays, confusion, court involvement, and unnecessary tax problems during one of the hardest moments of their lives. For business owners, the financial consequences can be dramatically larger. The good news, most of these problems are preventable. A properly drafted will, powers of attorney, beneficiary review, and corporate planning can make an enormous difference for the people you leave behind. Because estate planning is not about the death, it's about making life easier for the people who care about you the most.